Welcome to the look at 2025. This is the Transactional Entertainment Law Year in Review. My name is Keith Cooper. I'm the Vice Chair of the Beverly Hills Bar Association Entertainment Law Section. And on this particular occasion, I'm also the moderator of this panel. So I will be doing the speaker introductions as well. I wanted to mention at the outset that this section, the entertainment law section, is sponsored by Lawyers Mutual Insurance Company. Those of you who've heard me talk about them before, I will mention again, they've been doing this for 5 decades. Lawyers Mutual Insurance Company. They're the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that LMIC, as they go by, is directed by a group of dedicated lawyers. They offer special rates, competitive premiums for a wide range of areas of practice, including entertainment law. You could go to lawyersmutual.com. And actually, when we did the panel the other day, I took a moment to mention a cool feature that Lawyers Mutual actually has, and that is they have their own ethics hotline. So if you do secure insurance through Lawyers Mutual, it's very handy. You can call them up if you have an ethical issue or question or quandary, just to use that word. They will be happy to take the time to answer that for you. And for most lawyers, that can be helpful from time to time. So I wanted to now proceed to introduce our speakers. We have Ann Clark, Jonathan Handel, Emma Smizer, and David Shraga. Ann is a shareholder at Greenberg Traurig here in Los Angeles. She focuses on transactional entertainment media and intellectual property law. She represents production companies, studios, digital media companies, financiers, producers, and talent across all stages of development, production, distribution, and exploitation. Her practice includes AI-related deal structuring, union and guild matters, rights clearances, influencer and endorsement agreements. She was also named to the Hollywood Reporter's Next Generation list and is a member of the Television Academy and the NAACP Image Awards Nominating Committee. Jonathan Handel is senior counsel at Feig Finkel, also in Los Angeles. He represents talent, producers, production companies, and other industry professionals in transactional entertainment and technology matters, including union and guild issues. He previously served as associate counsel at the WGA and is special counsel to SAG-AFTRA. He's taught entertainment law as an adjunct professor at UCLA, Yale, USC, Boo, and Southwestern Law School. No comment. He is the author of several books on entertainment guilds and law and has appeared over 1,600 times as a media commentator and has been named to the Daily Journal's top 100 lawyers in California. He is also a member of the Television Academy and a research fellow at Rutgers University. Emma is an associate in the Interactive Entertainment Group at Frankfurt, Kurnit. She advises video game developers and publishers on IP licensing, transmedia, and interactive entertainment, co-branding, monetization, advertising, and data privacy. She's a certified information privacy professional and was named to Variety's Dealmakers of 2023 Up Next list. Emma co-founded the Legal Name and Gender Marker Change Project, which is a pro bono clinic serving the transgender and non-binary communities in the greater Los Angeles area, and serves on the emerging leaders board of the Association of Media and Entertainment Council. Finally, David Shraga. David is a private mediator at Shraga Resolution Services, specializing in entertainment, media, and intellectual property disputes. He spent the first decade of his career as a trial lawyer before transitioning to a decade in-house counsel as studio executive, serving as senior vice president and head of global television business and legal affairs at Miramax, VP of business and legal affairs at NBC Universal's International Television Studio, senior counsel at Universal Pictures, He serves on the executive committee of the entertainment law section of the Beverly Hills Bar Association, volunteer mediator for the Los Angeles Superior Court, and California Lawyers for the Arts. He's also a member of the Southern California Mediation Association. All of these individuals are experts, and all of them make me feel inadequate as a lawyer. Thank you all for that. In the meantime, we're going to transition over to the Transactional Entertainment Law Year in Review. This is our panel discussion. And by the way, we do have a Q&A, and I'm going to reserve some time at the end of this Q&A. So if you have questions, you can put them in the Q&A channel, and I will track them, but we will get them toward the end of the session today. Now, we have a few different topics that we're discussing. The main focal point that we want to cover is what happened in 2025, or at least very recently, that is affecting transactional deals, agreement drafting, et cetera, in 2026 and beyond. There are a few significant cases to discuss across a variety of areas. There is also going to be some discussion about the SAG-AFTRA agreement, largely involving publicity rights, name, image, and likeness, and that side of stuff. But the first case that I wanted to mention is Cruz versus Tapestry. There, the California Court of Appeal refused to enforce an arbitration clause contained in a website's terms of use. And the reason is because the platform failed to provide what they characterized as reasonably conspicuous notice, and they did not obtain clear user assent. This has been an emerging issue over time, and this particular court has addressed it. The court focused not on whether the terms existed, because I think they did, but on whether a reasonable user would have understood that completing the transaction constituted an agreement to those terms, and I think specifically in the context of arbitration. In this decision, it makes clear that enforceability is tied to how assent is actually obtained. And that means the specific circumstances under which the user presented with and agreed to the terms, and not just the language of the agreement itself. Consequently, enforceability now depends on how assent was actually obtained in practice and not just the written terms. In other words, there's a difference between including the term in your end user license agreement, among other things, and not just that it's there. It has to be conspicuous. And so the issue is whether the user was meaningfully put on notice and took an action that unambiguously signaled agreement. Now, again, this has been an issue that's been around for a while. So what I'd like to do is start with Emma and get her thoughts about this. For example, what does a legally significant asset flow actually look like in practice, and how should companies, if they need to, redesign their interfaces to preserve enforceability going forward? And a separate question that I have for you, Emma, I'll ask it again, but a separate question is, what happens to all these gaming companies, as one significant example that we deal with, when they've got these existing EULAs in place, and now this case comes along? Do they have to go back and rewrite the EULAs and send out and get new consents? How do you see all that unfolding?
Sure. So, hi, everybody. Thanks for having me. I guess first to kind of zoom out at the 1,000-foot level, I think with EULAs and terms of service, we're continuing to see a kind of move toward, I would say, like visibility, consumer protection, and expectations of consumers. And so I think what the Cruz v. Tapestry case is getting at is something that is, sort of expected at this point. When a consumer is interacting with terms of service or a EULA, do they know they're agreeing to these terms? And so one thing that I think, we deal with in practice is visibility. And it sounds maybe silly to talk about the actual color or the placement of text, but it is something that I'm actually looking at in my practice, is what is the actual user flow looking like from how the EULA or how the terms of service is presented and clicking through that. So it could be something like how it's presented on screen if you're scrolling all the way to the bottom and then you're clicking a checkbox. And just like it ends up being something where we're really looking at the exact user flow. And so in this case, I think it was a really good example of where you have it's like small text on it's gray text on a gray background, and wasn't really something designed to reasonably put a consumer on notice that they're agreeing to these terms. Also, I mean, I think this is like a side issue, but it is something I wanted to bring up in this section. There's a law in California, and we're seeing it across the states now. California, I think it's AB 2426, about digital transactions and giving users disclaimers when it comes to, not that they're purchasing an item, but that they're getting a license to something rather than having a continuous ownership over a digital asset. So I think for me and what I see in my work, whether I think it's prevalent in video game companies, but really it's kind of in anything. If you have an app, if you have a website, if you have something that is triggering the agreement of terms, and those terms contain language like a meaningful arbitration provision, you need to be aware of how you're presenting it to your users.
I think one of the interesting questions that this raises as well, that was interesting, zoom out here, is whether this principle that arbitration agreements have to be prominently disclosed, is that the end of it, or will, for example, limitations of liability, if there's an extreme limitation of liability in a terms of service or EULA, will the courts ultimately decide that has to be prominent? And how do you start? Everyone clicks through these things, without reading them. You can't possibly read every terms of service, and yet it raises questions as to the distinction between what the court sees and what people do in practice, it seems to me.
And I think generally, oh, sorry, go ahead.
No, I was just going to jump in and say, and I work as a mediator and an arbitrator, and I think it's an interesting issue, Jonathan, because arbitration provisions often get a special look from the courts, right? I mean, we're talking about the waiver of a constitutional right to a jury trial. There's a strong public policy incentive in favor of the finality of arbitration agreements under the Federal Arbitration Act. So I think this is one of those areas where, as a transactional lawyer, you may want to also give it some heightened attention, simply because it's such an important public policy issue. And in fact, we see new laws being passed by the courts to give folks ways to get outside of the scope of their arbitration agreements, when particularly involving things like sexual harassment claims.
Right.
These agreements, especially the arbitration clauses, I mean, the issue becomes it is now it's no longer an enforceable agreement, right? So when you're talking about redesigning and I think I may have maybe missed it because I was looking at one of the questions. I apologize, but do they need to redesign these things now and regain people's consent?
I think it depends on how it's presented to them in the first place. Like when was this entered into and how? And I think that's what the Cruz case is getting at is, did she really agree to this contract? Do you know what I'm saying? Like, what was it disclaimed to her enough? Was it clear enough that she had agreed to it? So I think for us, I mean, you're really deep in the facts as to when was the EULA presented or the terms of service? How was it presented to them? Is it clear enough that they're entering into a binding agreement? I think that becomes kind of a deep question of fact. So not to do the lawyer, like, it depends thing, but I think you really do have to look at the facts of like actually looking at the size of the font on the screen, the color of it. And that's sometimes what I'm doing on my end, is also thinking about across different mediums. If it's something on a TV screen versus, something like your phone, how does that appear to a user? Are they scrolling to the bottom? Is it a checkbox? When does it appear? Is it after they've already created an account? Is it before they've created an account? Is it before they complete a transaction? Is it after? So it's a long way of saying I think it really depends on the exact facts.
At the end of that, you still gave the "it depends" answer.
It does. I know. Sorry, but I do think it
No,
really
which is
matters.
fine. But but what in other words, thing is, like, a lot of people use kind of this click-through concept, and A lot of companies in the past and continue to do so, by the way, they say especially in the gaming context or, in a number of online contexts, by using the service that we provide to you, you hereby consent to these terms, to this EULA. Is that good practice, or is it better to require a much more clear affirmative assent some way? And in that regard, when you're talking about that, is it enough? Because I would not give this legal advice to anybody, but I know I always just scroll straight to the bottom and hit I agree at the bottom of it without having actually read it. Is that a good practice to use, or is there something now that you should require your users to do to affirmatively consent?
Well, I think what's tough is that even in the courts, they also sort of have the it depends response. Like it really depends how you're presenting it to them and what's going on in the user flow. And also, I think, there is a little bit of that tension between what's good legal hygiene and then what's business practice and what's going to happen. A lot of our clients want, a frictionless experience for users. So having this thing that pops up all the time that they have to scroll to the bottom up and then click accept isn't always practical. And I think it also depends on the exact, how restrictive are the terms that are in your terms of service or your EULAs. I think generally the kind of prevailing belief amongst companies today that are presenting a EULA is that you want something that shows them the EULA, you scroll to the bottom, and then it allows you to click accept to move forward. But again, I think it kind of depends on your risk exposure, your liability, and in your kind of visibility in this as to like what sort of friction you present your users. Because I think
that also interacts with the pop-ups about we use cookies here. You can cookie control. So the business desire to be frictionless is really running into a lot of conflict from legal here. That you've got the cookies and you've got to scroll to the bottom on the EULA. And by the way, another area that I would wonder whether there has to be courts may decide there has to be prominent disclosure is relates to AI, which is if one of the terms is we get to use whatever you upload as training material, is that going to shock the judicial conscience to the extent that that too will have to be prominent and maybe have its own little checkbox, along with the checkbox of arbitration, class action waiver, cookies. You've got already now 3 to 4 different things.
I did mention at the outset that I was going to hold all questions to the end, but Jeffrey Kravitz just came up with a really good one that I think is timely to this discussion. And that is, do they have to be in English, Spanish, native languages? How do you address that, particularly, on a global scale?
Usually for me personally, when we're dealing with game companies, it's such a global market. I'm probably dealing with local counsel in different jurisdictions about every week. I'm emailing with someone who's in like Brazil or Russia or in Germany. I think you want to make something that's understandable to the consumer. So is there an argument in another jurisdiction? Certainly where if it's, the prevailing language is one thing, but you present the terms in English, that they're agreeing to something that they don't understand, sure. And I think in different countries, there are laws that address that. So I think being aware of where your markets are, what you present to users, what's the language that you're presenting it in, I think is really important.
Yeah. On a side note, Emma, I agree to things I don't understand all the time, but that's just me.
But it's an interesting point though, as to like practicality, is anybody reading this? So if we make you scroll to the bottom, like are consumers more protected by having this language or having to scroll to the bottom? Like in practice, I think that's tough.
Which is a good segue to the question that I was going to have, because first of all, I don't think anybody actually reads it. And we always joke about, putting in, I think Noah Downs, his firm, they actually put in a terms of service one time, something about a zombie apocalypse, just to see if anybody actually picked up on it and read it. And the answer was no, they did not. So which leads to this question. Is it better, given this case, to separate an arbitration agreement out from the regular EULA or terms of service or whatever the case may be, so that they have to separately consent more affirmatively to the very specific arbitration provision?
It's not something I've seen currently, that there's like a separate consent for the arbitration provision or that it's
That's
built.
why I'm raising it. Should there be in light of this case?
I don't know. I mean, I think like it's hard because you don't want to be the first person to move on something like this. Should there be? I don't necessarily take from reading this case, I don't necessarily take it to say that that's what's being required. I think there's ways to give notice and make sure that you're putting the EULA properly in front of users enough. Does it have to require its own consent for arbitration? As of now, from this case, that's not what I read it to say.
I would say
Go
too
ahead.
here that there's, especially with respect to arbitration provisions, whether you're talking about a EULA online or talking about, in real life agreements, that, as I think it was David mentioned, obviously arbitration provisions are given special scrutiny by the court because you are waiving such important rights. And anecdotally, we had this actually come up in 2025. We were representing a company that entered into an agreement with a minor, as maybe many of you know, in California, when a minor's working in the entertainment industry, you have the ability to get that contract approved by the court, so they can't then later disaffirm by reason of their minority. And we went through that process, and then there was a dispute. And the one of the issues that came up, or one of the claims made by minors' counsel, was that they were trying to argue that the arbitration provision should be removed. They wanted to separate it out from the rest of the agreement and specifically disaffirm it, making some special arguments about how this was even more cumbersome on a minor, et cetera, and the minor wouldn't have had the ability to agree to it. That was never adjudicated by the court, but it does really bring up that issue. And I think especially when you're talking about who is clicking through this agreement, if that is someone who's under the age of 18, I can potentially see that becoming, something that someone would also try and use as a claim as to why it wasn't valid. But yeah, arbitration provisions do deserve, I think, I'm guilty of it too. It's like we have the standard language in our agreements. It includes an arbitration provision. But especially when we're having a minors contract where I'm representing the company, I make sure that in the parental inducement, whether or not we're going to go on and seek court approval, but in the parental inducement where they're saying they're responsible if the minor disaffirms, we do specifically refer to the arbitration provision in its own small provision there. So yeah, definitely something to consider.
Yeah, and this comes up, in especially again to revert this portion of the conversation to the gaming community, right? I mean, there's a massive online community of gamers right now, and a large segment of them are children. Now, you had mentioned, you get, and I've seen it in contracts, you get maybe the parents sign it, whether it's a personal guarantee. Some jurisdictions actually allow it, I think, to be enforceable. I think California, they do it with a personal guarantee, but I think there's other jurisdictions where the parents can sign on behalf of the minors and it's enforceable. But in this context, then, would you have kind of a separate parental consent provision or recommendation? I mean, how would you think to handle it? Because this affects an industry that's bigger than the music and the film industries combined.
I think we're also starting to get. Oh, sorry, go ahead.
Yeah.
Oh, no, go ahead.
It's
you.
Throwing that to Anne, but Emma, go ahead.
Oh, no, please go ahead, Anne.
I think this is really more your bailiwick when it comes to EULA and click-through. Yeah, so I defer to Emma here.
I'll just say quickly on that. I think that you're starting to get into the kind of like the big topic of age verification and knowing that your users are under the age of 18 or wherever that jurisdiction, like if they're under the age of 13, and getting proper parental consent. So I think it's, without turning this into an entire age verification panel, I think it's something that's incredibly relevant, and we're seeing laws right now that are dealing with it.
Equally important to the arbitration issue is the issue of waiving class action and class arbitration. And I would certainly suspect that the position should be that would need to be prominent as well. Although I don't know if Emma, I don't know if the case dealt with that specifically.
Oh yeah.
And I think, sort of combining really what everyone has said so far, there really is a spectrum in terms of how aggressive you're going to be to put this in front of folks, right? And Emma talked about tension between what is good legal hygiene, which is a great term, versus the business interests, right? And I do sort of feel like And I'm sure you've had agreements where the arbitration provision requires specifically initialing those types of provisions. And I'm sure there's something that could translate over to the digital context. As a practical matter, right? You're always balancing what's too much to put in front of someone, but at the same time, are they not going to assent to the arbitration agreement and continue to click through? So I think, you're probably with each of your individual business clients trying to strike that balance in view of how the law is evolving.
And I think there's also a similar risk if you're doing a click through and you pull out the arbitration provision, that someone could argue, well, if there's a dispute over another provision saying, well, that wasn't specifically pointed out to me. I saw the arbitration provision. I didn't see that one. So I think you have to weigh all the factors there.
I think also you really have to think about who your demographic is. Who are the people clicking through this? I think it's just as important to think about what you present as it is to understand and practice, like who's your audience here? Who's likely to be clicking through this? And I think you have to kind of tailor your approach and your risk accordingly.
And I'm gonna violate my rule for a second time, but there's another question here before I didn't want to leave the subject because I'm about to leave the subject, but I didn't want to do so without asking this question. The question from Jonathan Kirch in this case is, did the arbitration clause focus on the issue that David raised? That is, the arbitration clause requires a higher standard for consent other than provisions because it's a waiver of constitutional rights, which I take it by that means the constitutional right to a trial by jury.
Sorry, just so I'm understanding, he's asking about what the actual arbitration provision said in Cruz. I don't have it in front of me, so I don't know what exactly it said, but I think really what Cruz focused on, maybe this is the point of this, is not the language of the arbitration provision is itself important and needs to be considered. What the court was dealing with in Cruz was the assent to those terms, not just the terms themselves. How is this presented? Did this person assent to this agreement? I don't know if that's answering the question, and probably it's not.
In my mind, it does, but I'll leave that to Jonathan. We can revisit it at the end of the session if he has additional questions. So I'm going to move on to another subject. And this pertains to artificial intelligence because no one's talking about that these days. So I thought we should. Artificial intelligence, digital replicas, and contract restructuring. I think there's two cases that are relevant here, Cadre versus Meta. And this is still a great subject. And David, you and I saw a lot of this at the Entertainment Law Summit. A point that I will mention because it's going to come up here in this subject. But in Cadre versus Meta, the authors challenged Meta's use of copyrighted books, in this case, to train large language models without permission. And this has definitely been the trend here. And I think there's multiple courts that have actually ruled in this direction. But the court held that the training qualifies as fair use, emphasizing that the training is general purpose, or training a general AI purpose model is a transformative use. It did not serve as a substitute for the original work product or the works in the marketplace. And for those that aren't that familiar with this particular subject, basically, the issue here on fair use is you're taking an entire existing work in many instances, and the courts have held if it's input, it's not copyright infringement. It's fair use. You have to look at the output. And I'll mention it because this is what David and I saw at the Entertainment Law Summit the other day. They showed some examples where they used input under under actual fair use, but the AI, the generative AI on its own volition, to the extent that's an applicable word, created works that were almost literally identical to the existing works. People were saying, give me a Star Wars type of theme. And my God, the artwork that it spit out looked like Star Wars. And they had a Superman character, and I think it was Bugs Bunny, I think was the other character that we looked at. And it was strikingly similar. And so the output, not necessarily intentionally, was looking exactly like the input in some of that way. But the law at this point is that you can use this material for training AI because it doesn't substitute for the original works in the marketplace, which is what would...
Keith, I want to jump
Sorry?
in. I want to jump in. That is a very preliminary decision, and there are court decisions to the contrary, as well as the Anthropic book author settlement. So my take on the law is that it's actually unsettled, that there is an argument that it's fair use, but there are arguments that it's not fair use, and we don't have clarity on that at this point, which complicates. I know we're going to get to this in a minute. The guild negotiations, because the guilds have concerns, but the background law is unsettled, and that makes it harder to negotiate in these areas, and harder for transactionalists. To our point, for transactionalists to know exactly what needs to be contractual and what can be handled by background law.
Yeah, no, it's extremely important point. And yeah, we will cover that in a moment. And we are going to take a look at a contrary opinion, although I don't think it's that contrary, because I think it's a different context altogether. But at least in this instance, the court did accept that copying the entire work, which for those of you that don't know, is a relevant determination as to whether it's fair use. The amount that you're taking for the purpose that you're taking it, usually criticism, commentary, that news are typically fair use. But usually even in that context, you can't take the entire work. And it seems that this court was finding that, yeah, it doesn't matter. You could take the entire work for training purposes as long as there's no evidence of market harm. Again, from this buzzword, from the model's outputs. And what David and I saw the other day, you could easily make the argument these were substitutes for the original. But for transactional attorneys, right, the key, the key takeaway here is AI training is not automatically infringing. It really depends on how the model is used. But a somewhat contrary opinion came out, and that's the Thomson Reuters case versus Ross. Kind of reached the opposite result, but I think, and I'll ask the panelists, what their thoughts on this are. But what happened in that case is Ross used the Westlaw head notes that most of us are familiar with to train an AI legal research platform. But in that case, that AI research platform performed the same exact function as Westlaw. So it was the substitute for the existing marketplace, and the court did reject the fair use doctrine in that particular instance. So turning to agreements, though, this is now becoming a real negotiating point, right? So many agreements do not treat AI training as a distinct defined use. And after the Meta case, which talks about that it may qualify as fair use, but only if transformative, my question for the panel is, how should transactional attorneys moving forward in 2026 draft provisions addressing AI training, given that fair use is conditional and fact dependent?
Yeah, maybe I could jump in. I mean, I think, Keith, what you're really demonstrating is that there's such a diversity of analysis going on. These are really very fact specific and fact intensive cases, right? And Jonathan mentioned the Bartz versus Anthropic case, which, as we all know, just recently settled for $1.5 billion, right? And then, of course, there's the Kadri versus Meta case, two cases in the exact same courthouse in front of two different judges that came out very differently. And as you mentioned, fair use is a multi-factored analysis, and both of these judges found that the use was sort of wildly transformative in terms of ingesting these books in order to train these models. But the real distinction that mattered for them goes to what you were describing concerning market harm and the effect that it has on the market. And I think that translates into two pieces that you've already touched on. The distinction, really doing the work here, is between the inputs and the outputs. And on the input side, part of the analysis touched on the court's perception that there wasn't really a licensing market in place for training to take place. And I think what we're seeing, and to your question about what transactional lawyers are doing, we're seeing a change in that and a shift in how that's working, right? OpenAI is seeking out more and more partnerships across various forms of media, including news media, images, right? Shutterstock, Getty Images, things like this, where they're entering into license agreements in order to license this underlying material for training purposes. So I think from a transactional perspective, lawyers are seeing more of this going forward. Then, of course, there's the output piece, which is if you've licensed your work for training, or even if you haven't, is the output going to look substantially similar? And is that output potentially going to dilute the market and compete with your works? And that was a big issue that the court talked about in the Kadri case, and ultimately found that the plaintiffs hadn't presented any evidence of that at summary judgment and therefore dismissed it. So I think that the push-pull again is if you're on the side of the studio or someone who is licensing, creative works, you want to capture as broad rights as possible to use this work and license it for training, right? It's an asset. You bought it on a work for hire basis. Potentially, we want to be able to use this and monetize it. On the talent side, I'm sure the other folks on our panel are doing this all the time. You're marking up these agreements and you're trying to put in as much protection as possible to limit the use of your client's work for training. And if they are going to use it for training, there's going to be consent and there's going to be compensation, which is really the hallmark of this conversation.
And that gets us to something that's going on right now, which is the Writers Guild negotiations on their TV theatrical contract. Unusually, the Guild leadership last week publicly stated some details about what they're looking for. And I had predicted a week earlier, this is my victory lap, that the Writers Guild was going to be concerned about compensation for training data, because all three of the above the line guilds, of course, get residuals when when the film footage is reused, a movie or a TV episode, whatever, it goes from one platform to another. But the Writers Guild also, under certain circumstances, gets compensation when the script is reused. You use the characters and the worldview to create a sequel, or you do a reboot. You merchandise a character, you merchandise an object like a lightsaber, whatever. So the Writers Guild is even more deeply concerned with reuse than the Directors Guild and the SAG-AFTRA are. And indeed, a week after my prediction, the Writers Guild said, we are looking for compensation when our scripts are used as training data. Now that's going to be a very heavy lift, because the studio position is going to be, look, the background law is unsettled. There's some rando who doesn't own the copyright to the script, unlike us, because it worked for hire, as pointed out, can potentially make use of a script as training data. Why should we put ourselves, the owners of the script, in a worse position than some random third party and have to pay the writers for that use? So this is going to be very touch and go, frankly, in these negotiations, and it's going to be a very difficult, probably hard fought issue, even as we speak right now. They're in the room.
And Jonathan, going to the question also with the WGA negotiations and the question of input output, I thought it was interesting that one of the other topics they brought up was, because just as a little bit of background, as I'm sure people know, separated rights is such a huge part of what writers are entitled to if they are entitled to certain credits, certain higher level credits. And if you are working from assigned material, you're less likely to be entitled to those credits, and then therefore less likely to be entitled to separated rights. And I know the WGA is very interested in talking about the fact that assigned material, which is traditionally a book, or could be an underlying script, could be a story, it could be a treatment. They don't want AI generated materials to be labeled assigned materials for that purpose, which I think is, I don't see that being too much of an issue, because
well, it's not an issue now because they got that 3 years ago. You're exactly right.
Yeah.
AI generated material cannot be considered literary material or assigned material. That they already got.
Yeah. And we have in our agreements as well with the writers, whether, it depends on which side we're on, because we represent writers and we represent, companies that are engaging writers. But, in our agreements, we also all have a reference to what the writer can do in terms of what they're using in their agreements, in their materials. So if they're going to use AI, obviously they have to identify what the source was. This is at least what we include in our agreements, what the source was, and annotate, the materials that are AI generated. So we can make sure we don't have issues down the road.
Right, because AI generated material, at least if it's separable material, is not subject to copyright.
Right.
So that's a great concern for your studio clients, obviously, your producer clients.
So
Yeah.
and because we're going to cover the SAG-AFTRA material in just a moment, just a general question for the practitioners in this regard. What are your thoughts? I mean, do you believe that these agreements should expressly permit training or prohibit it? Or what would you recommend with respect to telling other practitioners should be the defined limitations in there? I'd like to get your thoughts in terms of your personal recommendations.
That depends on leverage, of course,
Yeah.
often. Go ahead, Emma.
I was just going to say, on the game side of things, I think what's interesting is that and I mean, I'm sure this is true as well for film and TV. There's a lot of functionality and use of artificial intelligence that is beyond just generative artificial intelligence. So whether it's image upscaling, you're working on motion capture, the revision or the refinement of code, I think what we've been doing, at least what I have seen, is it seems like when we are licensing materials, so when we are taking existing IP and putting it into a game, there tends to be a push for just a kind of blanket prohibition on artificial intelligence. So what we've been trying to do is kind of parse out generative AI, training in generative AI, and then the other uses for artificial intelligence that are outside of just generative AI. And that's kind of mirrored, I think, in what you see in the interactive media agreement for SAG.
I'm just curious if anybody else has any recommendations for any of the practitioners that are in attendance today.
Well, and I think one other thing I'd mention is that, this, as Jonathan said, the law is constantly evolving and changing. And these are some early decisions. There's something like over 100 copyright claims that have now been filed against the AI companies, and even more worldwide. And some of these decisions we're talking about may potentially be subject to review, we would expect, right? And so, the law often it goes behind the pace of business. And something we saw recently at the end of last year within the licensing landscape is the deal that was announced between Disney and OpenAI, right? Where they effectively announced a partnership to make some of the crown jewels of Disney's IP library available on the OpenAI platform for ChatGPT as well as for Sora, right? And interestingly, in that deal, Disney specifically excluded training from the scope of the license. Okay, and not surprisingly, given that they're in lawsuits right now against other companies claiming that unauthorized training is copyright infringement. So, they sort of sidestep the complicated issues that are involved in that aspect of the deal, but they're really focused on the outputs, right? And so I think this is something that's going to happen more and more. I think deal makers can be very creative about how they approach this from both sides of the input-output divide. And then, of course, the issues become, what are the guardrails? How are we going to monetize this, right? How are we going to enforce brand protection when potential user-generated content is being created based upon this underlying IP? So it's really, and it's happening at AI scale, right? On a global basis, potentially across platforms. So I think there's a lot of opportunity for lawyers to be creative around this and really stay up to speed with what's happening in the marketplace. Because I think that's what the clients are really trying to do, is to take advantage.
Something you touched upon. First thing I wanted to mention is for people to know that the SAG-AFTRA extended beyond just film and television. It does go into gaming because there are voice actors and motion capture and the like. So it's kind of crossing platforms, in my opinion. But when we talk about the AI and we talk about the use and we talk about the publicity rights that are involved in there, how do you guys, when you negotiate these agreements, negotiate in provisions with respect to separate exploitation rights for these? Do you address these on the front end as to, when you're granting AI rights for input or whatever purposes that you're doing? Because I know that there's the big tension. I think the basis of the SAG-AFTRA strike in large part was effectively talent losing control over their names, images, and likenesses as a result of this. So on the back end of that, and SAG-AFTRA did agree address this, but how does the compensation model work? Is it a separate category of exploitation? And if it is, how do you guys structure the exploitation aspect of that to compensate the rights holder?
Well, a very interesting example, actually, also from last year, is the commercials agreement, the SAG-AFTRA commercials agreement, and it has a provision that says that digital, that synthetic characters, synthetic avatars, cannot be used strictly for economic reasons, and if they are used for non-economic reasons, that 1.5 times the scale compensation that would have been paid has to be paid into the pension and health fund, along with a pension and health contribution on top of that. So that's an attempt to look at market harm in the labor market, market harm on the broad level, not displacing a single individual, where you have an avatar that resembles one individual, but in fact the market harm that the technology may create as a whole. It's difficult. I mean, to your question about what transactional lawyers should do, it does depend in part on leverage. If you raise a sleeping dog as to whether something can be used for training or not, if your counterparty has more leverage, they may insist that training be opted in, be allowed, when in fact, if you'd left it ambiguous, you might have been in a better place. I do have an anecdote, by the way. We don't talk that as much about trademark, but trademark is an issue here when it comes to characters, when it comes to logos. I did a kid's book where I wrote the text and the illustrations were done by AI, and I said, colorful illustration for a kid's book of a football player, for example. And later I looked and I realized his sneakers had a Nike swoosh, which I had not asked for, but there it was. And I'm like, okay, is that fair use? Is that infringing? I mean, this was on the output side. The input prompt was just exactly as neutral as what I told you. So it's, you just don't know what you're going to get sometimes.
So are you seeing that this is again a collective question, but by that I mean to the panel generally, are we getting a two-tier system between guild agreements and non-guild? Because there's plenty of non-union movies that are being created. Are we seeing disparate treatment? I mean, how is that in terms of the agreements reflected? Are non-union productions using these same AI restrictions and same AI systems, or provisions in the agreement?
I don't see a lot of difference between the agreements necessarily. And, I mean, I personally don't work with a lot of productions where it's not a SAG-AFTRA production. I more often there might be a non-union writer agreement. And again, as people have said, that all has to do with leverage. I think also, I believe it was Jonathan made an interesting point about, or how specific do you get in an agreement, right? So you are opening up cans of worms sometimes if you get really specific and list every possible right that you're going to have. Obviously, when you're working with someone who's a member of a union, there are already built-in protections for that talent, whether it's a SAG-AFTRA member or a WGA member. But I don't, I think it's always the case that, I don't right now see when it is a non-union agreement, that's typically more of an independent producer. And I don't think they're, even anticipating as much. They're just hoping to get the movie made and look at those things and potential traditional methods. You kind of have to get them to focus a bit more on the AI of it all. But I think it's pretty similar, that you're going to try and get as much as you can if you're representing the production company, and try and restrict if you're representing the talent.
So, question for you, Anne, though, like you do a lot of these WGA, the writer stuff. How if at all, does the Writers Guild handle it from SAG-AFTRA, for example? How are these reflected in the contracts? Are there differences? What are the similarities that you're seeing?
And how we've changed the contracts or the in between the two agreements. I mean,
Well, I was kind of asking, yeah, I mean, well, both actually would be great if you could address that.
yeah, I think, well, there hasn't been too much of a change, I would say, in the forms that we've used, really. Speaking to, obviously, in a writer's agreement, we find it's very important in terms of the input side to make sure that we know that no AI is being used. If it is a WGA agreement or a SAG-AFTRA agreement, we always have that collective clause that's saying that, the minimum terms of the agreement control. Of course, in the rights provisions, that's where, I've seen it the most. And we do tend to be a little bit more specific, I'd say, in terms of referring to the fact that we can use, AI, augmented reality, whatever we want to say in terms of, making it very clear that we may use it for training. Honestly, I've never seen anyone yet use it for training. We talk a lot about it, but I haven't. Maybe it's going on, but I haven't. And to the point of like, are you seeing separate compensation for these things? I would say no, because I have not at least had it personally come up in an agreement where that's on the table at the moment. Some sort of exploitation using AI. Maybe others have, but yeah, it's not gotten that granular yet in my experience.
All right. So, and because we are running out of time, there's a couple things I'd like to cover. So I was going to talk, at least I mentioned there's going to be an honorable mention about the music issue, and I've got some CCPA stuff that that Emma was going to address. But one kind of off-topic discussion, because we're seeing a lot of this. We see this definitely in the music business. It used to be, right, the record labels would go out and they would go see bands and venues and see how their following was, see how they performed, how their live show was. Now in music, I certainly in the influencer sphere, certainly even film and television, as I'm understanding it. I don't do a whole lot of work in that area, but my understanding is that even actors, actresses are being hired just like artists are being signed to labels based on their social media following. And I won't go into all the metrics that are utilized for social media following, but how is talent responding to this? Because not all talent are social media savvy, and it's now having a significant impact on their career. So starting with you, Anne, what are you seeing as the ramifications of social media on talent just getting jobs as entertainers?
Yeah, both getting jobs and then also just realizing the value that can come from having a social media presence outside of whatever job you're doing. I see it more actually. Well, I shouldn't say that. Gen Zers typically are pretty savvy with social media, but as if you have clients that are a bit older who have been in the industry a while, they're kind of looking over their shoulder or seeing other people or their peers having a big social media presence. And we do have clients come to us for advice on that, or we actually sort of prepare them for it. For example, if you have talent that are about to be on a show that's going to really, be a big break for them, they're going to be much more in the public eye. We work with also agencies that represent social media creators. And anyone who wants to, monetize the value of their brand, their personality, we do recommend that they work with an agency like that. It can really help a lot. And then for someone who really has not had much of a social media presence and wishes to have one, it's behooves them, I think, a lot to work with, a company that is going to assist them with getting their social media up and running, and kind of maybe front loading some content for them to use, because as we all know, from the talent perspective, well, actually from both, because if you have talent in an upcoming motion picture and you've invested a lot of money, one small wrong move on social media can be devastating, as we see all too often. So it is definitely something to get ahead of when you represent talent. And You know, you don't want to try and force someone into it if it's really not their thing. And building up a big social media, having a social media presence that really is monetized and generates a great deal of value, you have to post very, very frequently. So it's not for everyone. But those are some of the considerations that we look into for our clients.
All right, well, I want to leave some time here for some questions. And let me just look at some of these for you. And I'm sorry, Emma, I didn't get to the CCPA stuff. But let me just run through some questions. I have a comment from Uduak. Hello, Uduak. How are you? But it doesn't look like there's really a question here. Just a good a good commentary here. But similarly, we have a question here. It's not really a question, it's a comment, it's a short one, but I do have a question as a result of it, and I think it's relevant. He talks about in the book publishing world, authors must warrant that they have not used AI. And I think you're probably all seeing that in your practice as well. Would that be accurate?
Yeah, I think that's true. Whatever it is, whatever content is being delivered, that publishers will want to know that. You know, obviously companies engaging writers want to know that. So if content is being delivered in any way, we want to know that it's, you know, if you are, you know, it's not always prohibited, I would say, but if you're using it, it needs to be very, you know, annotated and clear what the source is.
All right, oh, sorry, go ahead.
I was
I
just
thought I
maybe,
heard
you know,
somebody.
the concerns are sort of primarily twofold. I mean, one is the concern that whatever they're receiving from the author is going to be protectable, right? Given the guidance from the Copyright Office about, you know, the copyrightability of works that involve AI and the need for human involvement. And then, of course, the other issue is, you know, they want to make sure that the things that are coming through are not inadvertently infringing on some of the underlying works that something may have been trained on.
So somebody raised a comment here in the comment section also. So I'm going to, because this will be the last of it here, and so I'm going to ask each of you in turn. I'm going to start with you, Emma. Again, this was more of a comment, but it's one that is really been discussed quite a bit of late, and that is this to each of you, just you know, because we're just about out of time, so I want to give each of you a couple minutes to both wrap up and answer this one question. What do you think is AI, Emma, starting with you? Do you feel AI is a threat to content creators at the end of the day and talent, you know, because of name, image, and likeness rights? Or do you think it's going to be a useful tool? I mean, you know, a lot of people are freaking out that, oh, AI is going to replace us. Other people don't feel that way. So I'd like to get your parting shots here and anything else that you'd like to add, starting with you, Emma, as to the future of AI. Is it as a big, giant global threat that people are scared of? Or do you think it'll be a tool like the internet was a tool to help productivity and help people going forward?
I think it's a little bit of both. And I think that's kind of the hard answer. It's going to be a tool that increasingly we use that does, I think, reduce the work of other people. Jonathan got at this idea earlier about labor replacement. And that's kind of, I think, the core concern. I mean, not to state the obvious, but that AI replaces what you're doing. And if it's work that you normally would have been compensated and instead AI is taking that place, then yeah, I do think it does pose a threat and it is a concern. Do I think AI is you know, is the concern going away? No, I think it's how do we use AI responsibly in a way that makes sense, both from a legal standpoint, but then also from, you know, making sure that people are credited for their work, compensated fairly. How do we address those concerns? And I mean, I think there's the legal aspect of it, but then there's also the kind of very human issue that underlies it.
But David.
Yeah, look, I think Emma really hit it on the head. It's the reality is it's here. It's a powerful tool. Um, it really comes back to responsible use, being thoughtful about this. And I think for transactional lawyers, the key is to understand what the underlying issues are and stay abreast of the developments so they can guide their clients through this new landscape.
Jonathan.
Yeah, I agree with both my colleagues, and compensation and consent are key. I mentioned that I did a kid's book a couple of years ago. It would have cost me, and it was a hobby project, would have cost me $16,000 to do the 100 illustrations. Instead, it cost me 50 cents, 8 hours of a $20 a month subscription. That sort of a ratio of 30,000 to 1, even if it were just 30 to 1 in cost savings, tells you that this is a tool that, as it continues to develop, is just going to be inexorable. There's no saying no, we're not going to use this when the cost savings are potentially that great. So shaping that and maintaining a place for human creativity, maintaining on-ramps for for entry-level positions, whether in law, whether in entertainment, whether in accounting, business consulting, white-collar work generally, is going to be a very, very difficult task, and is something that's going to require more political will than the country so far has evinced. But it's going to require that sort of thing, I think.
All right. And how about you, Ann? You're muted. You're muted.
Yeah, I agree with everything everyone said, and to build a little bit on what Jonathan said, in my world too, representing talent, I think political legislative action is probably going to be pretty important when you talk about, right now you can identify something that's AI most, pretty easily by certain, hints that it is, but that's going to change. I mean, AI's, I'm talking now about deep fakes and things like that. And that's going to evolve. So that concerns me in terms of, protecting talent's rights. And yeah, it'll be interesting. We're in the infancy. So we just got to do our best to stay ahead of it.
Yeah, deep fakes is one thing, and I would just mention, I don't do much litigation at all, but I did get sucked into one case, and it was a pro per plaintiff, and that pro per plaintiff turned out to be named ChatGPT. Everything they submitted to the court was unquestionably written by ChatGPT. And the interesting thing about that is the plaintiff in this particular instance was really horrible at it. And where GPT is concerned, garbage in, garbage out. But what I noticed through the course of this litigation, by the way, we got it dismissed because I know you're on the edges of your seat wondering. But what I noticed of it, even she, over the course of this litigation, which lasted about 8 months, was getting more sophisticated, getting better with using AI. And I think people that look at this issue globally, it is not sufficient to look at this and say, oh, this is what AI is. We weren't even talking about AI during COVID. And it's all we're talking about now, 3-4 years later. And I think people need to start looking at this, not at what AI is, but what AI will be in 10 years from now. And that's where I think our focal point needs to be. And I know that there's a lot of active, Dina Lapolt, very active in trying to get Deep Fakes Act passed. With legislation to protect content creators, to protect talent, because these are very real issues, and AI is getting more sophisticated. And I did not want to focus on AI today, but that'll be my final thought here. So with that, I think we can wrap up. We've gone a little over an hour, and I want to thank you, all of you, sincerely. I appreciate you doing this here with me today, and I really valued it, and I value all you, and I can't thank you enough for doing this. And I hope everybody that attended today enjoyed it and got something out of it. And thank you.
And thank you for organizing.
Thank you.
Thank you, Keith, and thank you to the co-panelists.
Yes.
Everyone.